Up in the morning and out to school. The teacher is teaching the golden rule.
In the background.
American history and practical math. You study them hard, hoping to pass. Working your fingers right down to the bone.
I'm certified financial planner Fred Snyder, also a registered financial planner representing Scotia Wealth Management. And we believe in the financial planning process. We believe that people would do better financially if they only had more knowledge. And we want to teach you that knowledge. We want to display and give you that knowledge, and we want to answer all your questions. And this, I remind you, ladies and gentlemen, is a live show. We expect you to participate in the show. I don't know if we're going to give anything away today. Oh, what the heck. Let's give away the workbook that goes along with Think and Grow Rich, my favorite book. You want to do better in your life. You want your kids to do better in your life. You should become an expert on the book Think and Grow Rich, because all the success secrets of the most successful people in the world come from that book. Napoleon Hill was commissioned to write that book by Andrew Carnegie back in the 30s. Andrew Carnegie sat down with him and said, look, the world needs a book on the principles of success. I'm going to give you a letter of introduction to the 500 most successful people in the United States. You go interview these people, put together a book, and we will make sure the distribution of that book is around the world. And that book is the Bible of almost every motivational speaker you've ever listened to. Everything is in that book. I don't want to take this show to talk too much about motivation, as important as it is. I want to kind of get down to brass tacks. I want to peel away the veneer and get right down to the core of things, because we're going to be talking about wills. And a lot of people are scared of wills because before it really takes place, you have to die. Okay? Not a good plan. Everybody wants to go to heaven, but nobody wants to die. All right? That's the price you pay for success, and there's a price for everything. But your will is a document that determines how your assets are distributed after you die. And I know from the questions I get, and I get lots of them every week. I talk face-to-face with a lot of people. I talk on the telephone with a lot of people. And I know that people are very ill-informed when it comes to wills. For example, I had a client last week call me and ask me about WESA. In the light of WESA, should I be looking at my will? And I said, probably. And joining me today is Tim Lack. He's been on the show before. He represents Lunny Atmore. He's a lawyer who specializes in real estate and estate planning. That's what he does. And you've listened to him before, and you've listened to many of his replays. I don't know if you got any books you can give away. You have any special books?
No, I don't, Fred.
No special books, so no giveaways there. How about a free will for somebody?
I don't think we're allowed to offer
You're not allowed to do that. Okay?
Because there's too many issues that could arise. I'm sorry. You just have me for an hour.
Not a problem. Because you got to go to church. You got to go to church right after the show, right?
I do.
And we're talking here on this station right now of changing the time from Sunday to Saturday because of the church issue. Because I know I have lots of my clients tell me, I listen to your show as much as I can, but too often I have to go to church and I miss your show, so I can't participate in the show. Give us a call. Let's talk about your money and how to keep it, because that's what this show is all about. You need a financial plan. You've heard the commercials that they play on this station all the time regarding the need for a financial. It disturbs me immensely that people do not have a document called a written financial plan, which is a blueprint, which says, here's where I stand today, here's where I want to go financially speaking, and here's how I'm going to get there. Now, to me, that makes a lot of common sense. And yet, that's a map to get you from point A to point B. And you don't have one. And then you wonder why you fail financially.
I agree with you, Fred. Since I've been on your show for the last couple of years now, your advice about getting on the financial plan has hit home with me, and I've created one. I've started mapping out where I want to be 5 years, 10 years down the road.
Well, the planning process, like I say, there's 3 P's, Tim. 3 P's. Helps you remember it all. There's 3 P's. The first P stands for plan. Everybody needs a plan. That's concrete. That's a document. Secondly, you need planning. That's a process. That means you look at the plan once a year, once every 6 months. whatever. You look at the plan on a regular basis and keep it up to date. That's planning. And last, you need products. You need the best products inside the plan.
Yeah.
You need the best life insurance policies. We were talking at the break about how when we look for a life insurance policy for somebody, we shop the market. We look at all the carriers of life insurance, and the premium from the least expensive to the most expensive for a particular policy can be quite high. It makes a big difference. So we shop for the best product, be it life insurance, be it disability insurance, health and accident insurance, all the various forms of insurance. And then we talk about the investments, whether it be stocks, whether it be mutual funds, whether it be preferred shares, income trusts. There's a whole myriad of investments out there. And we're like a financial department store. And on our shelves, we have all these products. And we have the best products because we're independent. I represent Scotia Wealth Management, which is owned by Scotia Bank.
Mm-hmm.
But I'm not forced to sell Scotia products. I can sell RBC products, Toronto Dominion Bank products. It doesn't matter who. I represent everybody. In order to get the best financial products, I can shop the market. So let's write that down. Shop the market. Nobody should do anything without shopping the market. Maybe you shouldn't even pick a lawyer unless you shop the market, okay?
People shop me all the time, especially when they're buying homes. They seem to think that process is rather straightforward, and I'm constantly giving quotes over the phone. So
Tim,
I'm familiar with that concept.
How many real estate transactions have you done in the last 3 years? What would you say? A good estimate. I know you don't count them.
Probably over 1,000.
1,000 real estate. So you got to be pretty good at that, I would think. Getting lots of practice.
Yeah, and I have good staff with me.
Okay.
And good junior lawyers.
And staff is important, okay?
Yeah.
So I know this deviates from our topic a little bit, but what about this 15% real estate tax? Is that going to slow the market down? Has it?
Just the week it was announced, if you recall, it was announced on a Monday and it was kicking in later in that week, okay?
Mm-hmm.
I saw foreign buyers who had not even entered into an agreement make an offer and expect to close in 4 days.
Wow.
And they were not inconsequential properties either. They were expensive properties.
Like 8 and 9 million, that kind of stuff?
In and around those numbers, yes. So a lot of the deals that could have closed earlier did, in fact, get moved up and closed before the tax kicked in. We're now 3 weeks later, 3.5 weeks after that tax is kicked in. I think a lot of realtors would agree with me and other real estate lawyers that a lot of buyers who are looking to buy are waiting to see if the 15% does have an effect on the market. And I think we're too early to tell, but certainly the realtors are saying their buyers aren't as anxious in the last few weeks as they have been in the 3 weeks running up to that deadline.
You're a member of my mastermind group. I also have a real estate agent by the name of Fern Northcott, who's also on my mastermind group. It would be great to do a show, you, her, and myself.
Oh, we'd have a lot to talk about.
Yeah.
It seems like it's the biggest hot topic, and it has been for the 20 years I've been a lawyer.
And really, it's off of really what we want to talk about today.
I know. Well,
you're a lawyer,
and
you specialize in estate planning. So when it comes to the estate planning issue, you're my guy. Okay.
Yes.
You're not the guy I necessarily turn to for real estate issues, although you're not without knowledge in that particular area either.
No.
So let's talk about estate planning. First question, what is estate planning? What does it mean?
Well, you're asking a lawyer a question like that, and I'm going to go back to give the answer that you've given so many times on your show, and I never thought the word would come out of a lawyer's mouth when you talk about estate planning. It's about love. It's
love of family.
For 20 years, I never used that word to describe estate planning, but it makes total sense when you brought it up on the first show I was with you. It's about leaving the people that you leave behind, the people that keep on living after you pass away, in the best financial shape.
Yeah, best financial shape. They know what to do when you pass away. There's been instructions left. I actually had a cousin of mine call me one time. Her mother had passed away, which is my aunt.
Yeah.
And she didn't know what to do with the body. No idea.
Yeah, I get the strangest questions all the time when people pass, when people loved ones pass away.
So if you don't have a proper will, it's lack of love of family. If you love your family, you'll have a proper will. Now, lots of people are unsure about their wills because of WESA. What is WESA?
WESA is the new legislation that came in. I guess it's coming up to 2 years now. Okay, and they sat down with a bunch of smart lawyers and legislators, and they created this new legislation called Wills, Estates, and Succession.
So that's an acronym for that.
Yeah, so that's what it stands for. And it modeled itself very much after the Ontario legislation that kicked in a little bit earlier. And I think what they tried to do was give more effect, if I could just put it in a nutshell, give more effect to people's intentions and a little less on procedure.
Okay, well that makes a lot of sense, because really the reason you have procedure is so that you can effectively mitigate litigate your intentions.
Yeah.
Actually. So when you die, you're deemed to have sold everything you own at fair market value.
That's right.
That's called a deemed disposition. And a lot of people aren't aware of this. If you're listening to the show right now, do you know what a deemed disposition is? If you don't know what that means, it's probably time to make a phone call.
That's right.
It's probably time to make an appointment with Tim.
Or with you.
Or with me, okay. But a deemed disposition, the government says to your executor, because you're gone, you passed away. So whoever is running your estate, your executor, the government says to your executor, let's pretend that everything that Joel, who just passed away, died, let's pretend he sold everything, even though it hasn't been sold. If he sold everything, he would have to pay $4 million in tax because of the capital gains and all the rest of it. So even though he didn't sell it, send us the tax anyway.
That's right. It's an accounting issue, really.
That's what they do. So that's how the government gets a hold of your assets. Elvis Presley is said to have given 73% of his estate to the U.S. government when he passed away. 73%. And there was a time in Canada when we had estate taxes and succession duties. Succession duties were taxes charged by the provinces. Estate taxes were charged by the feds. And they did away with estate taxes and succession duties, but they sneaked in the back door with capital gains tax.
And they also have something called probate fees. Okay?
And probate fees.
So when you go to have your will probated, and maybe I should explain what that is, that's when you have a will and you go to the courts and say, we want this will to be effectively certified by the courts that this is the will and this is the way we're going to distribute the estate. And for the courts to do that, they take a look at the assets and they take a look at the liabilities of the estate, and they do charge a probate fee. It's about 1.25%.
That was 1.4, so it's 1.25?
Yeah, well, there's a little sliding scale for smaller amounts.
So it's approximately.
Yeah, 1.4 is just, you keep that in mind.
Now, there's ways to avoid probate fees, and I really want to focus on the problem. I don't think we've really driven that problem home enough. You have a future unfunded liability when you pass away.
Yes.
That's tax. If you have a mutual fund portfolio that you paid $100,000 for and is worth $1 million, you pass away, you've made a capital gain of $900,000. Half of that's taxable. That's $450. So give half that to the government. That's what the government is looking for in cash. Now,
and let's flesh that out a little bit, Fred. They're looking for it soon. They're not looking for it as and when your estate does actually dispose of those assets. They look, it like you said, it's steamed. It's an accounting issue. It's as though the deceased sold it on the day they died.
So some people would be wise to start selling profitable investments and offsetting those profitable investments with unprofitable investments to trigger those capital gains and losses on a regular basis rather than allowing them to accumulate.
Sure.
Okay, because of pyramids. Because you're just postponing the inevitable. Because unless you're going to live forever, someday your estate is going to have to pay that tax.
And I haven't figured out that part about living forever yet.
No, I'm working on it. Hey, they manufactured a black hole in a lab the other day.
I read about that. I don't know what that means to us. Although I don't want to be the one.
I don't want to
it.
get sucked into that black hole.
Neither do I.
But it's incredible the technology that we have right now. I was in London Drugs the other day looking for a printer for my wife, and I'm looking at the printers. They actually have a 3D printer that you can buy at London Drugs right now.
Unbelievable.
I don't know how many people know what that is, but I saw a demo on television. They actually printed a crescent wrench, moving parts and everything. I mean, the story is right now that they're going to be able to actually reprint a human heart using body parts within 10 years. You won't have to get somebody else's heart. They just print your own.
Well, I'm a blood donor. They still want the real blood, not the fake blood yet.
Okay. So anyway, if you just tuned in, I'm certified financial planner Fred Snyder, also a registered financial planner representing Scotia Wealth Management. That used to be Scotia McLeod. Name changed more appropriately defines what we do. I define myself by saying I'm in the business of helping people accumulate more money by teaching them what they need to know to make better financial decisions. So that's what we're talking about. We're talking about the teaching process. We're talking about financial decisions. And we're focusing on estate planning, which really has to do with your will. So there's estate planning tools. One of them is your will.
That's right. Let's
talk about what is a valid will. You have the floor on that one.
Let's talk about what a will is and what the will actually does. Okay. First of all, it should get rid of all the other wills. So if you have an older will, it says those ones are gone. This is my new will. Okay. Then you appoint someone to be your executor. Okay. And usually you want to pick someone who's a little business savvy, someone's got a head for numbers, and someone who doesn't procrastinate.
Should it be your financial advisor?
It can be.
Should it be? I know a client whose financial advisor is the executor, and I think that's unethical. I've had many of my clients ask me to be executor. I refuse to do so.
Okay. I'm the executor for a number of clients.
Okay.
For some reason, they think I'm trustworthy enough.
Well, but I think that's frequent. That lawyers do become executors. Yes. That's normal.
Okay, so you've named your executors, okay? And then the important part comes up, usually in a will. You actually have to think about the distribution of your estate to the people that you love. And for the most part, it's the surviving spouse and your children, but it doesn't necessarily have to be just those people. But I find that that's where most people start.
Okay, we have an issue.
Okay.
We have some beneficiaries of your will. Let's say these beneficiaries are your children. You got 3 children, A, B, and C, so you want to exclude C. You can't because of the Wills Variation Act, correct? Right or wrong?
Here's how it works. People do want to sometimes disproportionately give their estate to their children. In fact, as recently as this week, a client came to me and said he was only left a small portion of mom's estate, and one brother was given beyond the lion's share. It was almost all of it, and by the time he saw that, mom had passed away, and now he's scratching his head, wondering, why would mom have done it like that? Although he wasn't too fussed. Okay, but let's talk about, can the person challenge it? The courts in British Columbia are saying, okay, there is a moral obligation to provide for your immediate family. So the people who can bring on these challenges aren't obscure cousins back in Europe or elsewhere on the planet. They are the spouse and the children. And they can go to the courts and say, I wasn't provided for, and it's only because Dad was having a bad day the day he did his will. So that's why lawyers, when they're taking those instructions to make hard decisions for distribution, we have to be careful, and we have to get those instructions more than once, consistently and make sure that the person's of sound mind and
So
not
the question
under any
is,
duress.
but the question is, can you discriminate against your children who are beneficiaries?
Okay, I'll answer that. I don't like to use the word discriminate. Yes, you can. If you document it properly, you can disproportionately divide up your estate. So it doesn't have to be even Steven among the children. But if it is a really big or strange or different amount going to one child over the other, the deceased as well as the lawyer are best to have that well documented as to why you did it.
Okay. That's called the Wills Variation Act in British Columbia.
That's what it used to be called. It's now
not
under
called
Wesson.
that now?
Pardon?
It's been name change?
No, it's rolled under Wesson now.
So it's part of Wesson.
Yeah.
Okay. So let's suppose that I have this very huge estate and I want to discriminate against my children. What are some of the ways that I can do that? What are some of the ways that I can avoid probate fees and get around WESA or the Wills Variation?
Oh, there you go. That's a great question. For example, I'm dealing with an issue right now where a client wants to add her child to her property. When I say add a person to property, that would be where a person comes to my office and says, I want to add my child to the title of my property. And I say, okay, that can be done. And usually you can do it without property transfer tax if it's the principal residence of the person transferring it. The person then goes on title. Those two ways a person can hold title in British Columbia: joint tenancy and tenants in common. Let's not get hung up on the word tenancy and think about rent or anything like that. It's a legal term, joint tenancy. And Fred, you know about this better than anyone, about the concept of successorship. That means that if two people own this property jointly, if one of them dies, the other person becomes the immediate owner without it going through probate, as you were talking about earlier.
Okay, let's get a little more specific. I've had in the last month or so, I've had several clients into my office that have had property, the house they live in,
Yep.
principal residence worth $7 to $10 million.
Wow.
Big ones. Okay, free and clear.
Yep.
Now, this deemed disposition tax that we were talking about earlier doesn't apply to your principal residence. It only applies to other things that you own. In the case of your principal residence, though, if you pass away and the property is only owned by you, the value of that property goes to your estate, becomes part of your taxable estate, and you have to pay probate fees on it, correct?
That's right. The deemed disposition generally tracks live dispositions, the same sort of taxes.
But so if that property is owned, let's say you want to avoid probate.
Yep.
You set the ownership of that property up with you and one of your children.
Yep. Or more than one.
With joint rights of survivorship. Okay? Rather than tenants in common.
Yes.
So if you set it up that way, you pass away, it does not become part of your taxable estate. There's no probate fees. And your child, Joe or Jim or whatever his name is, ends up with the property.
Or, as I did last month, a little old lady was scaling down, buying herself a condo, and added her 3 kids to title with her.
Sure. Yeah.
So when she dies, the 3 kids become the owners without mom.
What happens if those children also have another principal residence?
Well, that place wouldn't be their principal residence. So then they're faced with the issue of having to account to our friends at CRA in Ottawa when they go to dispose of that
So
property.
it won't be tax-free like a principal. It won't be treated as a principal residence, but it will bypass the state.
It'll bypass mom's estate when she passes away ahead of the kids.
It starts to get kind of a little complicated sometimes.
Sure.
And you really got to watch that. Let's say that the property is set up tenants in common.
Okay.
What's the problem there?
The tenants in common is separate and distinct from joint tenancy. That's where, let's say you and I own a place together, Fred, tenants in common. Then my half or whatever share we decide to put on title means I can give my share to somebody else. It forms part of my estate. When they go and check what I own,
I may have a complete stranger as owning half the house.
you could, yes.
Mhm.
And you do see that with some businesses, and more often than with real estate.
Why would anybody do that?
I think tenants in common. I see more often when people are getting in the market with perhaps a business partner, a friend, maybe another family member, but not an immediate family member, where they want to say, "Your half is your half, my half is my half."
Okay. So you have a situation there which could get a little messy sometimes. Get a chainsaw, cut the house in two. You own the west half. I own the east half.
There is legislation in place for dealing with disputes like this.
Okay, so we have a situation where we can bypass the state and really, to summarize, what we should try to do wherever possible is die without an estate, or at least don't have anything in the estate, if you can avoid it. If you have an RSP or a RIF or a tax-free savings account, you can name a beneficiary. By naming a beneficiary, that bypasses the state.
That's right. That's another good way of avoiding
insurance policies. You never make the estate the beneficiary of anything if you can avoid it. Okay?
That's probably good advice.
Maybe not in every case, but most of the time.
That's right. And most people might be familiar with that, is that whether it's a pension plan, you mentioned a RIF or an RSP, you get to name a beneficiary. So those assets don't typically form part of the probate assets that you pay the probate fee on. Rather, the value in those products go to the beneficiary so named.
Okay. What is an executor?
An executor. It's a lot of people are scared of that term. A lot of people are scared of the duties. A lot of people are fearful of what it entails. So many people come to me here having heard about horror stories about being an executor. Well, it's only a horror story if the deceased has left his or her affairs in a state of awful mess. Okay, the executor has to safeguard the assets, identify the liabilities, make the application for the probate, and distribute the estate. I mean, there's more to it than that, but those are again, safeguard the assets, identify the liabilities, bring on the application for probate, and then go to the distribution, and probably do the last tax filing. That's the last fifth important one.
I got a checklist up on my screen here, which I'm just looking at. And so we're talking about the will. We're talking about provincial legislation, because legislation is provincial, right? Is there any federal legislation when it comes to wills?
Other than just the Income Tax Act, which has lots to do with the deemed disposition that comes from death. But otherwise, it is provincial legislation that governs this.
And when somebody comes to you to have a will prepared, they should come to you with an inventory of assets. They should have a list of their assets.
Yes, that's part of my checklist.
Because if you got to do that, the bill's going to be bigger.
No,
kidding.
Yes, well, again, but because assets do change over the course of a person's lifetime, the identifying the specific assets, while helpful, a lot of people can do a will without identifying those assets. Your executor at some point will have to identify those assets. But at the time of doing your will, it's about what we talked about, love, and about providing for those people that you leave behind, and maybe that's just done by as a percentage or a fraction.
So estate planning is about will or love. We have to go to the break. So we're going to go to the break, and when we come back, we'll continue talking with Tim about estate planning. Don't go away.
That was busy.
Oh.
You and I, but no one's calling in.
Well, I think it's the time. I think
it is early.
Like, we never get any calls in the first hour here.
Sure. Can you do me a favor? It's great if you want to move and if you want to stand, but can you err more towards this side? Just because we have a camera there as well. And
Yeah,
just
sure.
right on the edge of it.
Oh, okay.
Yeah,
I didn't
no.
realize that.
It's totally great. It's totally fine. I got you in most of your shots.
Okay.
But this way, if you're gonna move towards the window, and then you can still keep moving.
Yeah.
Thank you.
Maybe I just don't want to be seen.
That's also a thing.
Heard is okay, seen is okay, too. All right. Okay, we're back. And again, I remind you, ladies and gentlemen, this is a live show. We're talking about your money, more importantly, about your money and how to keep it. And I'm talking with Tim Lack, and we're talking about estate planning. We're talking about wills. We're talking about really you can't take it with you, and what's next best if you can't take it with you. You need a good estate plan, and estate planning is all about love. So, Tim, are there any special situations regarding wills that we should address that you can think of? Like, how about making your own will or using a lawyer?
Notaries and lawyers both do wills, and I do have people who have tried to create their own wills by buying the do-it-yourself wills kit. I think as people read through those do-it-yourself kits, they see that there are more issues that they should be thinking about. Maybe the guardians, if they have young children. Maybe providing for a child who's incapable of providing for themselves. Maybe they want to leave something to charity, and the way you leave part of your estate to charity is important because it has to be identified very specifically or the courts won't give effect to that. So yes, I think for the few $100s or whatever it costs, attending before a notary or lawyer is important.
What about mental capacity?
That's really important, and thanks for bringing that up, Fred. Whenever I'm meeting with someone as they're older and they're talking to me about doing a will, I have to assess, and sometimes it's not enough for me to do the assessment, and I need a doctor's note to see if they have the capacity to make those hard decisions, just like any decision, though, whether it's a will or some other important financial decision. You probably have to do it as well.
Well, mental capacity is always a consideration.
Yeah, and there's duress and pressure and.
Okay, what does the term duress mean?
Well, if I'm getting a phone call from a child saying, "Here's what I want Mom to do with her estate," I should not be getting my instructions from one of the beneficiaries. I should be getting clear, consistent instructions from the person making the will.
But what happens if their mental capacity is lacking?
Well, if I'm concerned about it, I can go back to have a doctor, like a medical assessment done, and that's why. Guess you know what, Fred? You said people should be proactive, and that's why you should be proactive because you don't know what's going to happen a week from now or a year from now.
A while back, you and I visited one of my clients, and there was some question about mental capacity. And in your opinion, she was quite lucid.
I thought she was savvy.
Yeah.
She lived on her own. The house was well kept. She spoke clearly, and she made a great cup of tea.
I got a note here. It talks about two wills. How can you have two wills?
Okay.
And it says two wills can be better than one.
Yeah. Okay. And let me explain how that works. Okay. If you have two wills, okay, you have to have different executors, and then the executor that, let's think of, okay, let me scroll back a bit. Here in British Columbia, if you have a will, your executor could say, well, there's my instructions. I'm going to distribute the estate in accordance with the will. And the person does not actually have to have it probated. And I've heard that straight from the staff at the probate registry at the courthouse. People go and get it probated at the probate registry because they want the courts to say, yes, this is the will. Go proceed as set out in that document. And there's issues about giving notice and all that fun stuff.
Now we have this strange word called probate.
Yeah.
Okay, because really we sometimes are guilty of using words the public doesn't understand.
You're bang on.
What does probate mean?
Okay, that's when, someone's died. I've gone through their through their personal belongings. I found the will. Okay, there's the will looking at me, and it says, here's what I want to do with my estate. Here's who I want to give the money to. And here's who I want to be the executor. So the executor says, oh boy, I got this will here, but am I sure it's the right will? Shouldn't I have someone sort of certify it, put the seal on it and say, go do it?
In other words, is it a valid will?
Yeah.
Is the will valid?
That's right. And that's when the probate registry, and there's a few hoops you have to jump through about giving notice and the proper notice to the beneficiaries or the people who could be beneficiaries.
What happens if the will isn't valid?
Well, there's people who die without wills, or there's people who, for some reason, their wills are invalid, and we have a term for that, and that's called intestacy.
So if your will is deemed to be invalid in the process of probate, because of the process of probate, you really are dying intestate.
It could amount to that. I think Wes is going to allow the executor, the probate staff, and the courts more flexibility in giving effect to as much of the will as they can. Whereas, in the past, it seemed as though we had a very strict guideline as to if it worked or if it didn't work.
I have a great book on wills, and anybody who calls the show will get a copy of that book. So if you want to participate in the show, give us a call, and I'll see that you get a copy of that book. Get on the line and give us a call. Once again, if you just tuned in, I'm certified financial planner Fred Snyder, also a registered financial planner representing Scotia Wealth Management, used to be Scotia McLeod. We are financial advisors, and that more appropriately defines what we do rather than Scotia McLeod. Wealth management is what it's all about, and wealth management requires a plan. Peter Drucker, Dean of Modern Business Management, used to say, if you can't measure it, you can't manage it. So you got to be able to measure your assets, your liabilities, your income, your expenses. You got to be able to take a look at your goals. I don't know. I ask this question all the time. Do you have any well-defined financial goals? Most people say no, or they don't know what I'm talking about. Okay? How can you get somewhere if you don't know where you want to go?
I agree with you. And ever since you brought that up when I first met with you, I've got that little note stuck to my computer as to, short-term and long-term goals.
I once heard a guy give a talk, and he got up on the stage, and he said, you know something? He said, I have never played hockey in my life. But he said, if I played hockey, I could outscore Wayne Gretzky. Providing you blindfolded him, spun him around 2 or 3 times, and put me on the ice with no nets. Okay? And it's true, because that is what we do. I use the analogy often. It's like me, when I leave the station to go back to Vancouver today, put a bag over my head. Do you think I'm going to get to Vancouver?
No.
There ain't no way. And at least I know where I want to go.
It's a straight shot on Oak Street.
Okay. Because I can't see what I'm trying to do. Okay. Comes up all the time. Where do you keep your will?
Okay, that's a simple
Really
question,
great
but it's a
question.
smart question. Some people keep it in a safety deposit box.
Yeah.
Some people keep it in, a filing cabinet or a safe at home. Otherwise, I have hundreds of wills in a fireproof safe at my office.
So you should keep a copy of your will with your lawyer?
The lawyers usually would keep a copy when it's signed up, and I think it's a good idea that your executors have a photocopy of that will, so that when you pass away, they can go to it right away and see if there's anything in there. Because a lot of people put stuff in the will that, they don't need to put in the will. Things like burial wishes or issues surrounding their funeral. They want a certain kind of funeral or not a certain kind of funeral. And for some reason, people put it in their will, even though quite often those issues are handled before the will is actually pulled out and looked over.
There's two documents. We alluded to one of them earlier that people should have. And the first one is called an enduring power of attorney.
Yep.
And the second one is a representation agreement. What do they like? What is an enduring power of attorney? If I have a client right now, there's an enduring power of attorney in place, but the client is lucid. So the person with the enduring power of attorney can't make financial decisions, I don't think, you correct me if I'm wrong, without the permission of the person who granted the power of attorney.
Well, the whole idea of the power of attorney is that someone is making those decisions when you're unavailable to. So I guess it's a question of what's your availability. Is it because you're on a cruise? Or is it because of your lack of capacity? Or is it because you're otherwise want someone to attend at the bank and make those decisions for you?
But if you're mentally incompetent for any particular reason, that's when the enduring power of attorney kicks in.
That's what most people think about for the power of attorneys. I've signed lots of them up as people's health deteriorated. And let's not forget one little important thing about powers of attorneys. The person so named as the attorney has a duty of a fiduciary duty to the donor. That's the person giving those powers.
And if they mess up, they can be sued.
That's right.
Okay, we have a caller. Let's talk to Maria from Vancouver. Maria, welcome to the program. Hi, Maria.
Hi, good morning.
Good morning, Maria. How are you?
I am really good, and Will's really get me interested in calling and talking to you and asking you different questions. So my question this morning is, people do their will either by going to a notary or a lawyer, or if they can't afford to do that, they write up their own and they have a couple of people witnessing it. My question is, most people, they are not rich. They own their home, and that's the biggest part for their life, right? So why is it they write up a will, there is no change during, let's say, 10, 15 years, but a will can become invalid. What makes it invalid if there's no change and the person decides, my children are so many, I'm going to give this and this and this, but it can be invalid when the person passes away. I would like to know what in the will causes it to be invalid.
Maybe a change in legislation.
Maria,
for
it's
example.
an interesting question. I more often wills become invalid because of something that happened right from the onset. That it wasn't properly witnessed. Maybe the appointment of the executor, there was something wrong with that.
It has nothing to do with the fact that it's 9 years old, because if I'm not mistaken, I've heard that you should redo a will every 4 or 5 years.
I don't recommend people changing their wills that often. I usually just say if there's been a change in your life circumstances or the life circumstances of your beneficiaries. Okay, so what I mean by that is perhaps your spouse has predeceased you and you have to start turning your attention more to the children as beneficiaries and less to the surviving spouse. Maybe one of your child has a handicapped child or themselves has become disabled as a result of an accident or some other medical issue. And that's when it's time to, say, wait a minute, this child of mine is not going to be able to care for him or herself. Perhaps they should share a little bit more of my estate than my other child who's very well-to-do and otherwise has got the perfect life.
So that means I am correct in saying that if there is no changes of any kind, it doesn't matter how old the will is?
Look, I'm going to answer. I'm not going to answer it I'm going to say I've probated lots of wills, recent ones, old ones, and very old ones. Okay? And a lot of those old ones, they name the surviving spouse as the executor, and they name the spouse and the children as the beneficiaries, and whether it was done last year or 10 years ago, the courts will look at that and say, yep, all the ingredients of a proper will are there. Let's give effect to the will.
But it doesn't hurt to check.
Doesn't hurt to check. Because memories are short. You sometimes forget what you put in that will.
Okay, well, I thank you so much for clearing that up, and I'm sure the listening audience appreciates it too, because it's a delicate subject. It's one that sometimes doesn't want to be dealt with.
Well, we'll see, Maria, we'll see that you get that book, because that's all covered in that book. We're giving that book away.
Well, I appreciate that very much.
Okay, and I can't tell you how much I appreciate your call. You're a frequent caller, and I appreciate your support. Thank you.
Thank you. Take care.
Enjoy the rest of the weekend. Bye.
Thank you. Bye-bye.
We have a caller from Ontario. William.
He must have a big antenna.
William, welcome to the program.
Oh, thank you very much. Thank you very much. You're chap. How are you doing today, Fred?
Pardon me?
How are you doing today?
I'm doing fine.
Good. Taking care of all those people that are trying to plan out how to die successfully, I guess, anyways, eh? Yeah.
Yeah, right.
Well, it's quite a complicated situation. I just got to turn this down a bit, as she asked me.
Okay.
Here's what the situation is. When you, I don't know whether your chap has had this, name 3 executors, best 2 out of 3 supposedly win the decision court, like if they have to decide something one way or the other. But it turns out that there's a conflict between one of the executors and the other 2, and basically it's at a standstill because neither one of them wants to proceed with a lawyer or doing anything. So 2 or 3 years now have elapsed since the death, and nothing's happening. Is there any laws in the country that basically force that to go ahead at somehow, some way to public guardians or something or other, or does it sit forever?
William from Ontario, great question. Thanks for bringing that up. There are lots of times where there's an impasse with an estate. And you raised a good question. When you name more than one executors, they may not always be of the same opinion on how to proceed. But there is a duty of executors to keep the process going. They cannot simply stand still and do nothing, okay? And there is time frames that they have to move ahead with the estate. And let me just flesh that out a little bit. So maybe it's one of the executors who wants to move forward, bringing on a court application, or one of the beneficiaries. It's not going to be easy, and it may not be cheap, but the courts will force the executors to keep things moving along, okay?
Well, here's the point that they've both done. They've both systematically very careful to not do anything that would recognize them necessarily as being locked into the executor job. Apparently, the first time you make a move that looks like something that would be an executor, then you're committed more or less without application to back out. But neither side has, and they've carefully manipulated to very carefully not have to do anything. The funeral, everything was pre-planned while their powers of attorney. So that all took place, and all the OAS things got cut off and all that, the paperwork. But meanwhile, it's sitting in the process with the money still tied up at a financial institution, which basically just
William,
it's going to sit there for so long.
Are you an Ontario resident, BC?
Well, they actually are. Yes, they are.
Okay, so they're what, BC or Ontario?
Well, they were both. The lady that died was in Ontario, and the three executors are all Ontario
Because you
executors.
got a different set of rules in Ontario than you have in BC.
Well, I heard that they were very similar as far
They
as
may
the
be,
happening.
but they're different.
They are.
They are
eh?
similar. And I'll gonna repeat what I said earlier. I think it's
Yeah.
incumbent upon the people who want to move the process forward to bring on that application and
So
force
it
the
would have to-
executors to take the necessary steps.
Yeah.
to
So
get
the
state
only
moved.
person that would probably do that is a beneficiary that's sick of waiting for their share if
That's
they knew
right.
there was a share.
That's correct.
Yeah, that's what I'm thinking. Some of those are BC residents.
There is
William-
a duty on executors to move things along.
I can't tell you, William, how much I appreciate your call. We have to move along. We're running
Yeah.
out of time. We got some
Okay.
more callers on the line. You take
Well,
care.
good luck.
Enjoy
And
the rest
keep
of the weekend.
informing.
Bye for
Yeah,
now.
you too. Bye-bye.
Bye-bye. Let's talk to Megan from Burnaby. Megan, welcome to the program. Hi, Megan.
Oh, hi, Mavis.
Hi, Megan. Are you there?
Yes. Good morning.
Good morning, Megan. How are you?
Okay, I want to know the executor is to protect the assets. Now, what do you mean by the asset? What does it entail?
An asset is what you own. Anything.
Anything.
Anything you own is an asset.
Oh, I see. So the household things and
Yeah, everything you own. An asset is something you own. A liability is something you owe. A
Okay.
liability is a debt. An asset means ownership.
okay,
It can be stocks, mutual funds, antique cars, furniture. It can be anything.
okay. All right, thank you.
So that's called an asset. And we've been talking about executors, and I'm going to drill down into that a bit when we come back. We really can't tell you much. Appreciate your call. You take care.
Thank you.
Okay, I haven't given the numbers out too often today. The number to call is area code 604-280-0650. If you're calling long distance, it's 1-877-280-0650. You can log on, www.cil650.com. And if you're shy or reluctant to talk on the air for any reason, Frida's down at the office right now, area code 604-737-3512. Long distance, 1-800-66-11495. I'm going to drill down on the issue of executors because I want to talk about, I got here some of the duties of an executor. Okay, so maybe before you accept that position, if somebody asks you to be one, you should check the duty list. Because if you screw up, you're liable. There's a list there, who or what. So you got to hear Provincial Health Ministry, Service Canada. In Quebec, it's all there. There's a whole list of all the things that you have to do. Special situation for an executor, make claim for death benefits and apply for survivor benefits. Okay? Now, to do that, you're going to need a copy of a death certificate, certified copy, or the original.
I make lots of certified copies. I think you're safe with a certified copy.
Some people want the original.
You know what? You can order more than one. So, and they're
Okay.
about $15 a pop.
Also determine if there's another lawyer involved in the deceased, or if the deceased was a business owner. So there may be other lawyers involved.
Yep.
Who when is there no surviving spouse? That's another. I mean, let's say that two people were killed at the same time in a plane crash. Who's the survivor? I think that's what they're talking about.
Let me answer that one. I think right now the courts are saying it's the younger of the two.
I think it is the younger. Yeah.
So
okay.
I don't know what would happen if they were born on the same day.
So you got to cancel the CPP or the Quebec pension plan. You got to cancel the social insurance card. You got to cancel old age security, cancel veterans pension, obtain the original will, make appointment to discuss tax issues, stop pre-authorized payments. There's a lot you have to do.
And you know what? Some of them should be done in short order as well.
Yeah. Okay. Cancel the driver's license, make claim for insurance policies. I mean, I've had people pass away that the spouse doesn't even know what insurance they have. We have to find out about their insurance policies.
I believe it. I've seen the mess that deceased have left behind, and the best thing you can do is for your executors have all your important affairs and papers and accounts and all the stuff of that nature together in one spot.
Arrange for the final meter readings on for your utilities, cancel credit cards, close accounts, inform and prepare to close any investment accounts, cancel club memberships, for example, the golf club. The list is endless. And really, you should talk to somebody like me. Let's say that your best friend wants you to be an executor. Say, well, I'm going to talk to Fred first.
Yeah.
Okay? Or you. Get a list of executor duty. It's freely available on the internet. Understand because if you fail, you can be sued.
And so many times people want to make executors people who are far away. I counsel people against that. Your executor has a lot of things to do in and around where the deceased lived. I know the world is getting smaller with the internet and communications, but still, the executor has, there are physical duties involved of safeguarding those assets and taking care of the house and what have you.
So you're out there, you're thinking, okay, well, here I am. I'm pursuing financial independence. I'm investing $1,000 a month into an investment portfolio. It's growing well. My portfolio is suitable. It's getting good rates of return. I'm going to get to where I want to go financially. I'm happy. Somebody else should be an executor. You got to understand that can be a liability if you're not careful.
Correct.
I've had lots of clients many, many, many times ask me to be an executor. I refuse to do so.
For certain clients, probably that's wise.
Okay. You have to file all required tax returns for the deceased on a timely basis and pay all tax owing.
Yep. Sorry.
You got to treat all beneficiaries fairly and impartially. You got to protect and maximize the assets of the estate.
I think we've hammered that today.
Yeah. You got to provide information that is needed to beneficiaries and third parties. This is a full-time job.
And that's a really important one, okay? There are strict duties on providing notices to beneficiaries.
How much do you get paid for being an executor?
Well,
or should you get paid?
There's two ways you can get paid. One is under the legislation. There's a percentage amount, or in fact, you're within the will itself. The deceased could say how much the executors to get paid. It's not inconsequential. There's, for the big estate, there's money out there for the executor.
Well, I think I heard 5%.
That's right. That's what the legislation is. But again,
can
within
it
the
be
body
more
of the
than
will,
5% or less?
Within the body of the will, you could top that up.
Could be higher.
Yeah.
Okay. Can it be less?
I think the executor can waive the like it does. The executor does not have to take that money.
Now, unfortunately, we are out of time. Where did it go?
I don't like when you
Time
say out of
marches
time
on.
when we're talking about death, Brett.
It's like the guy said, I'd rather be over the hill than under it.
It's nice to see
I'm
you
not
again.
afraid of death. I just don't want to be there when it happens.
Yeah, that's right.
Okay. Anyway, we have to go. Ladies and gentlemen, thanks for listening. Thanks for participating. Same time, same station. Next week. Bye for now.